Welcome to In the Name of the Law with your host, Liisa Speaker from Speaker Law Firm. Joining her today is Steve Sinas from Sinas Dramis Law Firm, along with Mary Chartier and Takura Nyamfukudza from Chartier Nyamfukudza PLC. Now let's discuss some remarkable stories and real cases.
Welcome to In the Name of the Law, a legal talk show about real people with real legal problems. In today's episode, we're going to talk about school change cases, the Andary auto case, and an interesting criminal defense case. Stay tuned.
In the name of criminal defense.
Today we want to talk about the impact of plea bargains in the criminal prosecution system. Joining me are criminal defense litigators Mary Chartier and Takura Nyamfukudza of Chartier Nyamfukudza. So how prevalent are plea bargains in the United States?
Lisa, they are unbelievably prevalent. 95% of all criminal cases get resolved by means of a plea bargain.
Why is it so high?
Well, if you think about it, the police know and prosecutors know that, as Takura said, 95% or more of those cases are going to plea bargain. So the arrests are really high because people are going to ultimately end up taking a deal. Very few cases are going to see a trial, and then you don't have anyone examining bad conduct when it comes to the police or when it comes to the charging decisions of prosecutors.
So the people who are pleading are guilty though, right?
No.
No. Lisa, you may recall we actually did a show on false confessions. Once you are in the crosshairs of the long arm of the law, there are lots of pressures on a person once they've been arrested and charged. And even after a case is resolved, that scarlet letter you carried with you for many, many years after that.
So why would someone plead if they aren't guilty?
Lots of reasons. One is once you are in custody, a lot of people don't get out because of an extremely high bond. And I've said many times before that it is expensive to be poor, right? So some people, just to get the heck out of there, will end up entering into a plea bargain. And, a lot of people are stuck in jail awaiting for trial. And also for us as litigators, it's a lot more difficult to prepare for trial. Not impossible, but we would much prefer that our client be outside rather than in custody waiting for trial. Some people wait for years, literally years, without having been convicted of anything.
And there's also the trial penalty, too, that comes with plea offers that are made to clients, which is usually a huge factor in people making the decision to plead guilty.
Mary, can you explain the trial penalty?
Sure. So essentially, someone might be charged with an offense, for example, and they're looking at in federal court a 15-year mandatory minimum, or in state court a 25-year mandatory minimum. But the prosecutor will come with an offer where, and both of those are real cases that we've had, where, for example, in the federal case, the mandatory minimum will be dropped to 5 years. Or in the state case, they'll just eliminate the 25-year mandatory minimum, and then they'll just go by guidelines or cap at jail time or whatever it might be. And that last one we really had, where the client was facing multiple charges with the 25-year mandatory minimum, and then they ultimately came with an offer where they would cap it at jail time. So would an innocent person take that deal? Of course they would. I mean, you know what I'm saying? Because they're looking at, I could spend 25 years potentially stacked, so the rest of my life in prison, or I could be out in 12 months, and that client had already been in jail. So you have people taking these offers, not because they're guilty, but because the deal is so either enticing to them, or it falls in that middle ground where it's not as bad as 15 years, 5 years, they think, well, I've already been in for a year and a half or 2 years. I only have 3 more to go. And so you have lots of innocent people pleading guilty. And the frustrating thing about it is, if you really think as a prosecutor that someone committed this horrendous act, then why on earth are you making them this offer? And why, if they go to trial and lose, are you so adamant that they should go to prison for this lengthy period of time? Because you were fine with them doing a year or 2 years or 5 years rather than the 15 or 25 or whatever it might be. I mean, there's a disconnect there, at least to me, logically speaking.
And also what this means is when the government's case does not get challenged, there's no reason, absolutely no incentive to change any of these bad practices, right? If it's not broken through their eyes or through their lenses, then there's no reason to change it. So it reinforces bad conduct.
Do people know the full extent of the government's case before they make a decision to plead guilty?
No, especially not in federal court. We've often described it, actually, I think a judge, the first time I heard it, described it as trial by ambush. In state court, for example, we know a minimum of 30 days who the witnesses are going to be. Not so in federal court. It's not unusual to hear a long list of witnesses on the first day of trial, and you're hurriedly trying to write it down. And some AUSAs are so kind that they'll tell us the next day, not necessarily the order, but the people they may call the following day. And the Jenks Act, which means that they can withhold certain material, right? You may not know if somebody is coming up, and when they do, they may tell you, they being the government, they may hand you a statement that this person made testifying at great length right as they're walking up. So you never know who's coming, what they may say when they're coming. So you really don't know what you could be opened up to by having a who knows come and testify at trial. So no, the short answer is no, particularly not in federal court. So
people in federal court actually go to trial without knowing what witnesses are going to be called at trial against them.
Yeah, and I'm sorry, I'm laughing, right? Because it's so ridiculous. It's not a laughing matter at all. And I think, Kurt, you're laughing too. But I mean, it's crazy. You'll sit there, and so the government has to tell the jury, read off names of the people they anticipate calling. But that doesn't mean that they can't call somebody else. So if they don't think that anyone's going to know Larry Smith from Texas, they may hold that witness's name back, and they frequently do. And so they'll call your next witness, government, a week into trial, and they call Larry Smith. Your client will look at you and be like, who's that? And you're like, you tell me, right? I don't know who it is, because we've got no materials on this person whatsoever. I mean, again, Takura said it, and it can't be said enough, trial by ambush. So when clients are making that decision in federal court, they have no idea necessarily of the evidence that the government has against them, both favorable and not favorable.
So, okay, is state court any better?
It's slightly better, right? I mean, you're supposed to get a witness list. You're supposed to get discovery. We've had all kinds of issues with that. I mean, as Takura knows, we had sanctions against a prosecutor's office twice because of discovery issues. That's when they had to write us a check. And that was after a pattern of discovery issues in the same case. We exonerated a gentleman who spent 26 years in prison for a murder he didn't commit. The DNA that exonerated him was on a shelf in a room that had never been disclosed to anybody. So, I mean, the actual evidence that exonerated him, the government had in their possession the whole time. No one had disclosed it. And then we just exonerated Jeff Titus in June. And on that, the police had witness statements pointing the finger at another man, a serial killer, and that had never been disclosed. And no one found that until a defense attorney went and actually looked at the file. And lo and behold, it had never been disclosed. So, I mean, is state court better procedurally? It's supposed to be. At least you know the landscape of witnesses ahead of time, and you're supposed to get statements. But there are these really egregious practices that occur over and over again.
Right.
So are there other reasons the plea bargain system is problematic?
Oh, yes. One is, for example, prosecutors will add a lot of charges just so they can say, oh, well, look, you started with 15 and we'll dismiss a dozen of them. And actually in federal court, because of what's called relevant conduct, right? They have actually every incentive to charge you with a boatload of crimes. And the conspiracy is one that they frequently throw on there because I think it's the easiest one to prove. And then even after some get dismissed, you can still have your sentence increased, even though you were acquitted by a jury or they dismiss them as the result of a plea bargain. So
that's in federal. So that's, to be clear, that's in federal court.
Yes,
And not
yes.
in state court. He's talking about federal court. And lawyers have tried to challenge that. And so far, the U.S. Supreme Court has not taken that up yet.
And also some prosecutors will threaten adding additional charges if somebody runs the preliminary examination in state court.
So are all plea bargains bad?
No, right? They're not all bad, right? Sometimes it is the best outcome for the client when you look at the evidence against them and it's really overwhelming. Ultimately, though, it's up to the client to make that decision at the end of the day. We've had clients who haven't taken offers that I think they should, and then we won at trial. I have other clients who, have taken an offer and I think, boy, I think we really would have won this at trial. So they're not all bad, but I think that there's an over-reliance on them tremendously in the criminal prosecution system to make the system continue to move forward. And I think they are far too prevalent.
Thank you, Mary and Takura.
Thank you, Lisa.
Thank you.
In the Name of Criminal Defense is brought to you by Chartier Nyamfukudza, PLC. In the Name of Family Law.
In the family law courts, we've been seeing a lot of parents fighting over where their kids should go to school. So today I have with me Oakland County family law attorney Catrina Farrugia, who's going to help us understand these disputes between unwed parents and divorced parents regarding their children's school. Welcome, Catrina.
Well, thank you, Lisa. It's a pleasure to be here.
Can you help us understand first the difference between joint legal custody and sole legal custody and how that impacts the decision-making of parents?
So oftentimes we see parents sharing joint legal custody. Joint legal custody means that the parties are going to confer with each other on matters that are going to have significant effect on the minor child's life. So religion, education, medical decisions, these are all things that the parents should be working together to adopt a harmonious policy. Sole legal means you get to make those decisions without input from the other parent.
So that means the cases that we keep seeing are all between parents who share joint legal custody, and when they can't decide, they have to go to the judge and have the judge figure it out, right?
They do. We've got a special word for that. We call that a Lombardo hearing, and that's where we have an important decision that we need the judge to weigh in on because we just can't figure it out on our own.
Well, let's talk a little bit about the different types of school disputes that these parents are having. Sometimes we have one parent who wants to change the school that the child is going to, or even the school district, and other times we have disputes where the child has not started school yet. And so they have to figure out, where is this kid going to start school? Can we talk a little bit about that?
So when we want to change what the child is already doing, the parent that wants to make the change is going to have the higher burden. They need to show by a preponderance of the evidence that whatever that change is going to be that they're advocating for is in the best interest of the child. And in a situation where we've never selected a school, we're doing this for the first time, still the same rule applies. We do need to do what's in the best interest of the minor child, but I see it as more of a little bit of a battle of the schools, to the extent that in this hypothetical on my mind, we're looking at both parents being created equal, and now we just need to figure out where this kid's going to go to school. The court's going to essentially have a battle of the schools.
Isn't it possible that, especially in the context where the parents have had 50-50 parenting time and the kid is just starting school, if they live far enough apart, isn't it possible that the change or the selection of the school could impact the parenting time schedule and also potentially the established custodial environment of the child?
In the school context, we would potentially create new problems when we move that far away or when we have to select a school that's that far from another parent's home. Now we have to figure out, can we continue to do the same parenting time schedule? How are we going to get the child to activities? School functions, parent-teacher conferences, all of these types of things could be affected by the distance now between the two schools.
So in the context where one parent's just asking to change the school where the child has been going, and it's not going to change custody, how you've worked on these cases, how hard is it to convince the court that the school should be changed? What is like going on in that case to, even though it's only a preponderance of the evidence standard, is it hard to prove?
It is hard to prove that a change should be made because the court, like I said, favors stability, so they don't like to make those kinds of modifications. You're taking the child potentially away from their friends, from activities that they might be involved in, extracurricular things, and making a modification like that is something that the court weighs very heavily. They're going to potentially even interview the children about their preference. And a lot of times a parent thinks that this is the best thing for the child, but only from their perspective, and not recognizing that they might be taking away time from the other parent. They might be modifying something that the child, even though they might come home from school complaining they get too much homework, but actually do enjoy that the nature of the school and the entire environment that they're in presently.
So is there any difference in the analysis if the fight between the parents is whether the child goes to a public school or private school?
I think the analysis is going to be the same, but there are extra factors to consider. If you're advocating for a private school, it might be something you can afford right then and there, but what about future years? If you decide that you want to send your child to an expensive exclusive school, $20,000 with tuition, and you're able to do so at that time, what about next year? If you've lost your job or there's some sort of situation, medical situation, you can't provide the same kind of income you had before. Now what you've done is changed the child's school, disrupted their educational environment, and now we have to find a new one, and we're right back to battle of the schools again. Where are we going to send this child and which one's going to be the best?
So do you have any important things that parents should remember when they're considering or they're facing a school change dispute with the other parent?
I think the best policy is try to work it out with the other parent. It's very likely that neither party is going to be pleased with whatever the judge does, because it's seldom a solid win all the way. Maybe you get the school you want, but now parenting time has changed and you have to do more of the driving. Maybe the situation becomes something where you could have maybe worked with your partner and come up with a school in the middle, and you could have used school of choice. Likewise, to the extent that the parties confer together, maybe that is a scenario where private school might be an option that you do want to consider, because both parties are capable of paying for that, and they say, listen, I'll contribute if you contribute, let's pick one in the middle and not create a situation where it's difficult for me to go to the soccer game. So.
And I guess my last question is about when you're actually doing these trials, and I know you've had them, putting on a case about which school the child's going to go to. Who are your witnesses? Is it just the parents who are testifying, or do you have to bring in other people to show that one school is more appropriate than the other?
So oftentimes I will encourage my clients to hire an expert, which is expensive. So they do have experts in schooling that will testify as to the, I keep using the phrase battle of the school, which school is better? Higher ranks, higher scores, teacher to student ratios, all of those things are something that you can hire an expert to testify to. I have on occasion actually subpoenaed and had principals or school administrators come in so that they can talk about the numbers that their school achieves. So it's not just a he said, she said, I prefer this, this is why this is better. The court is really looking as to what is in the best interest of this child, and right down to the numbers.
And I think you said something that was really important. I want to make sure it's not missed, is that if the judge has to decide the case, it can be an expensive process to put on a full trial about which school.
Very expensive. Oftentimes it's $10,000, $20,000 to have one of these types of hearings. And generally that money is possibly better spent on higher education as opposed to fighting where we're going to send the child to first grade.
Well, thank you so much, Catrina. This was really helpful today.
My pleasure. Thanks for inviting me, Lisa.
In the Name of Family Law is brought to you by Speaker Law Firm. Go to WLAJ.com for more information on today's topics and to view other In the Name of the Law episodes. In the Name of Personal Injury Law.
Many appellate court decisions are important, but some have a huge impact on a large number of people. Earlier this year, the Sinas Dramis Law Firm obtained a victory in a Michigan Supreme Court case that preserved critical rights for catastrophically injured people around the state of Michigan. Today I have Steve Sinas of the Sinas Dramis Law Firm, and he is going to tell us about this significant Supreme Court case. Hi, Steve.
Hi, thanks for having me.
So tell us about the big case.
So the case is commonly known as the Andary case. Andary versus USAA Insurance. But before we get to the case, I want to start out with explaining what happened to the Michigan no-fault insurance law in 2019. Ultimately, what happened in May of 2019 is that the legislature rushed to change the law in very significant ways. And one of the changes they were making is how medical care is paid for and how family members can be paid for providing care to catastrophically injured people. And they rushed these changes in, and the legislators had little time to even review what the law said. And they ultimately passed the reforms in the name of bringing down people's insurance rates. But there were many ambiguities and uncertainties about that law. And I was there at the Capitol the day they passed it. And there were so many questions people were asking. But one of the major questions was to what extent this law, these new changes to how medical care is paid for, would affect all those who were already injured and already claiming benefits under the no-fault insurance system. And let it be known that these people are claiming benefits for the most catastrophic injuries, severe brain injuries, spinal cord injuries. They need round-the-clock care, and their benefits were very important to them. And these changes were going to fundamentally affect how they could access care. And so there was this huge question about whether these changes would apply to them. And that's what leads us to this case. We represented two plaintiffs, Ellen Andary and Philip Kruger, and a medical provider in a case where we were arguing that these new changes could not be applied to these people in a retroactive way, that these people had rights under the old no-fault law and that they should not be stripped from those rights because the legislature passed a law for people going forward. So it was a retroactive argument that we were making in the case, and then it went to the trial court where we litigated it.
So can you tell us about how the case was litigated in the trial court?
Yeah, so the trial court is the first level of our court system. That's where we file our lawsuits. Trial courts are where trials take place. That's why they call them trial courts. But before a trial takes place, a judge can decide a case on its merits based on legal rulings and can do so through what are known as summary disposition rulings. And so the insurance companies, when they got our lawsuit, filed a motion for summary disposition where they said that our arguments that these new changes couldn't be applied retroactively to these people should not be entertained by the court, and that the court should dismiss the lawsuit. We also had other constitutional challenges to these laws in that lawsuit. And ultimately, the trial court here in Ingham County agreed with the insurance companies and said that these laws could be applied retroactively to our clients. And that was a very disappointing result that we got in the trial court, but we decided to keep on fighting.
So then your firm filed an appeal to the Michigan Court of Appeals, right?
That's right. That's the next stop on the ladder of courts. You have the trial court, the Court of Appeals, and the Supreme Court. So we go up to the Court of Appeals, and there we have to file our claim there at the Court of Appeals. It then takes several months to get the case assigned to a panel of judges. We waited over a year for that to happen. And then we finally had oral argument before a panel of 3 judges. And then we had to wait a few more months for the court decision.
And did the Court of Appeals decision make a difference to the people in this state?
It did. It reversed the trial court's ruling in favor of the insurance companies and found in our favor. And this was a really special moment. And I just also want to reflect that this lawsuit was really spearheaded by my partner and father, George Sinas. It was a team of lawyers. We all were fighting for these people after these reforms, knowing how vulnerable they were. But this whole endeavor was a whole lot of work, time, effort, and thought put forth by our firm, but especially George. And that decision at the Court of Appeals and ruling in our favor was really special. It ultimately embraced everything that we were saying in the case, that these changes shouldn't be applied retroactively to these people. And it resulted in the insurance companies being told then by the courts that they had to restore these people's rights. But the story wasn't over at that point. The story went to the Supreme Court.
Right, of course.
So at the Supreme Court, we were there because the insurance industry filed their appeal to the Supreme Court. And then that took another year, more than a year, to get through that process. We had to wait for the Supreme Court to take the case, and then they scheduled oral argument. And it was just about within a year that they issued their decision this summer.
So you had oral argument, the court makes a decision, and what happened in that Supreme Court case?
So we had the oral argument, and that's where you go up and on behalf of your clients, you argue to the Supreme Court why you should win, you answer their questions, and you have to kind of read the tea leaves about maybe where the court's going based on what they said at the hearing, but you never really know. So we had the hearing in March, and we had to wait all the way to this July. And ultimately the Supreme Court agreed with us and said for our clients who are people insured under a no-fault insurance policy that their families purchased and that they were covered under, that the legislature's new changes to the no-fault law couldn't be applied to them, that these people had bought these policies based on premium dollars that were assessed under the old law, they were depending on the old law, and ultimately the Supreme Court embraced our arguments that this legislation can be interpreted and applied to take away those rights.
Is there any questions that are left unresolved or any uncertainty left for people in the state?
There certainly is. There are aspects of this new law that were not directly addressed by the Supreme Court. So it's my understanding that the insurance industry is arguing that other aspects of the law that weren't directly addressed in the Andary case haven't been decided and can be applied to these people who were injured prior to the implementation of the law. There are also people who are claiming benefits under the old law but aren't doing so under their own policy. There's ways in which the old law was written that allowed these people to access benefits through other people's policies or through an entity known as the assigned claims plan. And the Supreme Court, in issuing its decision in Andary, said in a footnote that they're simply not deciding the issue for those people. So it was a victory for our clients, thousands of people across the state of Michigan, but there are some people who still don't know what the Supreme Court's actually going to say when it comes to their rights.
Now, Steve, we're almost out of time, but I feel like I have to say something about a guest that we've had on this show a couple of times.
Yes.
Brian Woodward.
Yes.
Who was one of the people that you were fighting for.
Right.
Because he was catastrophically injured, and I hope people go back and watch those episodes.
Yes.
And he had a life that he was able to create. And because of the old auto law, he was able to continue with that life until his benefits were cut off. Can you tell us what happened with Brian Woodward?
Brian was a friend and a client, and he epitomized all the good that the no-fault insurance system can do for catastrophically injured people. And he also ended up epitomizing how these new changes to the law are changing people's access to care, whether it be because they can't enforce their rights they had, or because the industry that provides them the care has been so affected by these reforms. And so Mr. Woodward struggled and struggled to get his care after these laws were passed. And unfortunately, he died on the same day that the Supreme Court issued the Andary decision. And so we fight in his honor and the name of all these other people who need their rights protected under this system.
Thank you, Steve.
Thanks.
In the Name of Personal Injury Law is brought to you by the Sinas Dramis Law Firm.
Thanks for joining us on In the Name of the Law. See you next week.
Thank you for joining us today for In the Name of the Law. Please go to WLAJ.com for more information on today's topics, and please join us next week for another informative show.